on this side, so many on this side. 3 adjournments for both of them. What is the cross-examination time? He will make this assessment and make a report and send the case to the main line of court. The judge there will see that he will give slots. This is done by pleasure. Then for each bunch of courts, there is a director of court administration. Judge will only adjudicate matters. He will not be bothered about how many cases are in the other court. He has to decide one case at a time. So this kind of timing, for example, I have to examine 3 witnesses. I am given 4 adjournments, not more. You can exhaust if 2 adjournments as a matter of course, 2 more at a price. You have to pay a huge cost if you want to have intelligence and directory of extending it. So this kind of system, when it goes there, now you find out what is the optimal output of a judge. He can say, can he dispose of, say, 800 cases in a year? Can it is processed and cooked and brought to him? So, you know the history of that court. What is the average filings of that court? Add 10% extra. And then allocate the judge time for each. And make this case flow system, which is controlled by the controller of court administration. He monitors it according to, that's a system, I'll give you that also. The 2 professors in England have developed it, and they were engaged by the Lord Chancellor to manage the case flow in Bedfordshire County Criminal Courts. To a lady professor and from I think some university. Not one case went out of schedule. So what you have to do is, first thing is, choose one court in North India, heavy court, one light court, one heavy court and light court in South India. Choose it and introduce this system and try it for 1 year, how it works. It will work beautifully, and lawyers have to be taken into confidence. Without their cooperation, we can do nothing. And in planning it, they must persuade one Chief Justice of a High Court to take one court as a pilot project and introduce it, see the magic court. And they are prepared to spend tens of thousands of crores on this thing, aimlessly. This is all filtered away. It must be oriented to procure certain results. And this is the arrear backlog is disposed of by a system of self-liquidating judicial personnel. That is, supposing today in a particular court there are 5,000 cases. 1st of January you take care of the future case. The arrears are disposed of by a set of judges proportionate to the arrears. That will be a self-liquidating mechanism. You dispose of 100 cases, one judge is released, he goes to the other stream. New court system. He'll be in the old court system. And if for example, in the first year, before cases are ready and ripe to reach to this man, the new system, cases appropriate to that stage. For example, there is A stage, B is negotiation, C is trial, 4th is judgment. A, B, C, D. Supposing there are cases in C group already, mature for it will go there. New court till the new judge gets the feeder line reach him. Till then you have to sit quiet. That appropriate number of cases will be distributed to this new court. They will deal with it under the new system at the appropriate stage. There are 4 stages, let's say. This system has been virtually worked out by Justice Bharuka He had come here last week.
Bhoruka, you said.
Bhoruka, Bhoruka.
Bhoruka.
He is in Delhi.
Bhoruka means must be Rajasthani, Marwadi.
Yeah, Marwadi.
Yeah.
Marwadi, but he settled down in Patna. He was a judge in Patna. Then I transferred him to Karnataka. And he was the chairman of the E committee. It was under his guidance that they spent nearly 900 crores improving the infrastructure of the courts. Every judge, every magistrate has been supplied, every judge, 15,000 judicial personnel have been supplied with laptops and printers.
And program was also given, software?
Yes, the software, first class software he has made.
He retired as Chief Justice?
No, he retired as Judge of the High Court of Karnataka. Now he is practicing. Then he was appointed as the chairman of the E committee, electronic committee in the judiciary, and he prepared an excellent report and gave it. And it was his time. He has done a lot of work, and he is prepared to give all the software free to anybody who is prepared to use it. My concern is that we must put this system. Of course, it takes a little experimentation. One Chief Justice must, of some state, should take this seriously. We started in 5 pilot projects when I was Chief Justice in Karnataka. 5 districts were taken. But we didn't put the scientific thing. We had other methods of dealing with it. Results were spectacular. And
why was it given up? Was it not continued then after?
See, the whole trouble in the judiciary is every fellow has a brainwave. He thinks that there is always a better thing. There is, but you don't have the time or the patience or the mental attitude. You are overworked. Judges are overworked. And the time and leisure they have their own problems attending to them. So it becomes difficult for them to deal with this in a sensible sort of way. So this system must be taken, given to a Chief Justice, who will implement it in one district. There are people, and this must come through the Lawyers Association of that place. You must win over the hearts of lawyers. If they make it, judges, courts will lead. Otherwise, they will always set up these lawyers to oppose it. So we must win over. Give an example in Bombay, Rafiq Dada did splendid work. A wonderful man. He's a very noble man. And there are, see, Bombay is a place where this could be experimental because judges are independent. For example, Chandrachud's son, he's a bright boy. He can be trusted to do this. If Rafiq Dada, Venkatchailah and a few others take it up, Soli Suramji and all that, I can say.
So you want this system to be actually implemented in the High Court or in the subordinate?
No, subordinate.
Start with the
yes, only subordinate court. We'll start with magistrates and Munsi's court.
City civil courts? City civil courts?
City civil courts.
And sessions?
Not sessions is, that's another cup of tea. Sessions cases is a terrible story. 10 years a session case doesn't go on. Eyewitness is cross-examined, not cross-examined for 5 years. How will a case remain? My goodness. You know, and the people have given it up as a lost cause because the studied non-cooperation from the principal stakeholder. Only accepting the litigant. Nobody cries over this.
Yeah.
This is the problem.
Yes.
And you have got to be a litigant to experience the agony of the process.